Welcome, visionaries. Hello, how are you? Welcome to the TLO Live. This is our second time going live, and I am grateful for everyone who is showing up and who is here and who will watch this later. This is just a Q&A format style for us to answer and have a discussion, for me to answer questions that you might have around the topics of business, nonprofit, and intellectual property law. And this is just a way for me to help provide some clarity around questions around the law. With that being said, I cannot give you legal advice. I am providing legal information, again, to help provide any clarity around the law, questions that you may have generally, and to help kind of direct you in the next steps that you might be taking in your business or as a creator or in your nonprofit as a leader. So with that being said, again, thank you for being here. My name is Maresa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I am happy to jump right in with your questions. If there are targeted topics that you may want me to talk about as we start to develop and continue these live conversations, you all let me know, and I'm happy to do that as well. But with that, I will let you all kick it off, and I will start to answer any questions that anyone may have. Are there any questions so far? I don't see any popping up yet. So with that, while I'm waiting for some questions to come through, I will just talk about some of the changes in the law specifically. So if you are a business owner, if you are a creator, even if you're a nonprofit leader and you are building your brand, you are building your nonprofit reputation, or you're creating works that you want to protect. One of the things that has changed just this month in November 2024 is that the fees for the trademark for federal trademarks at the USPTO, the U.S. Patent and Trademark Office, have increased. And it's not just one fee, but they have increased all around. So pretty much all the fees have increased. Additionally, there is a new fee that has been added. That if you do not fill out the application correctly, if there is a space missing, if there is information that was not provided, and the examiner has to come back and ask you for information that should have been provided on the application, there is an additional fee for that. So there's going to be $100 charge for every time the examiner has to come back and question you, maybe about an address, or maybe about an email address or a phone number that was missing from the application. So these are the types of things that are happening. In addition, the filing fee is now increasing from $250 per class of goods and services to $350 per class of goods and services. So what does that mean? That means if you need to protect your brand in multiple categories, so let's just say, for instance, that you have a restaurant and you have restaurant sauces. Those are two completely different categories. And so instead of paying $500 for the filing fee for those two classes, you'll now be paying $700. So that is an almost 50% increase. And so with that, if you are looking to, and there's a proposal for those increases, for those fees to increase again in January of 2025. So if you are thinking about, if you are considering protecting your brand, protecting your creative works, you need to do so now. You need to jump on that now. I have some YouTube videos and I have a trademark playlist that can give you some information about if you are looking to, DIY your trademark application. I do recommend for many people getting an attorney, because the trademark process is quite a legal process. And at this point, there is there are so many trademark applications being filed daily that the likelihood of confusion or the likelihood of receiving an initial refusal and having to argue that is pretty high at this point. And so having an attorney who can argue that for you and overcome any refusals is going to be probably in your best interest and save you money in the long run, as opposed to filing on your own, getting an initial refusal and not being able to adequately respond, or not being able to respond on time, and then losing all of that time, all of that effort, and all of the money that you've put into getting the application filed. So that is just one of the changes. The reason for the increase, yes, is there a reason for the increase? The reason for the increase in these fees, one, is because there was such a long lag since 2020 on the application process. So prior to 2020, trademark applications at the federal level used to take about 9 to 12 months, and now they're taking longer, on an average between 18 to 24 months. And so there were so many complaints from attorneys like myself who represent clients who need their brand, who are, trying to, get merchandise and, marquees and spend money on the brand, and they want to make sure that they have that brand secured. And taking 2 years to get a trademark back has just been completely inconvenient and unacceptable. And so there were a lot of complaints from trademark filers and from attorneys. And so what the USPTO did over the last year and a half is that they've hired almost double the amount of examiners. And so one of the reasons for the increases is they're paying for all of these new hires that they've hired to streamline the process and to make the process more efficient. But also they're in the process of changing their internal procedures and processes, updating their equipment, updating all of their IT, updating their software. And so all of those changes are part of why these increases are occurring. The other reason that they've cited for the increase is that specifically with having the $100 new fee for incomplete applications, is that it's going to help streamline and help to incentivize for people to do and submit applications, correct applications, which will then help them to get through those applications more quickly and efficiently. So that is why they are, having these increases. Now that was what they cited. Those were the reasons that they cited for the increases that are happening now this month in November. The reason why they're doing another increase in January, I don't know. Maybe they had, another look at seeing what their increases were this month and determining that they were not enough. And so maybe that's the reason why they're going to implement this additional increase in January. But if you are considering, please, please, please think about doing so sooner rather than later. I see another question here. What would be the best way to structure my LLC, DBA, and non-provisional patent pending? Okay, so those are three completely separate things and entities. So I'm not exactly sure what you mean by structure them. So an LLC, let me back up. A DBA is not an entity. A DBA is just another name for, but it does not create an entity. So if you're a sole proprietorship, unless your business is your exact legal name, then you would need a DBA because it doesn't create a separate person, right? But if you have an LLC does create a separate person. So I like to say, Kampala, I hope I'm saying your name right. I like to say if you have Kampala, the person, and then you create an LLC, then the LLC is not Kampala. The LLC is a legal person, so we have Lisa the LLC. And Kampala and Lisa are two separate people. And so what the DBA does is it allows Lisa the LLC to go by Lisa's middle name. Same person, but now Lisa, the DBA is Nicole. So Lisa Nicole, that's her whole name, one person. And the DBA allows Lisa to also be called Nicole, but it doesn't create another entity or another LLC or another corporation or another anything. It's just giving another name to the same entity or company. So in asking how to structure that, there really is no structuring for a DBA because it doesn't have any legal status. With a non-provisional patent pending, there's no way to structure that either necessarily. So the patent, if the patent is pending and it's a non-provisional patent, then the real difference between a provisional and a non-provisional patent is that there's going to be a 1 year kind of head start for one, and the other one, there's no 1 year head start. And so when thinking about the patent, there's no real structure to that. It's just that the patent is pending and you're going through that patent process. So I hope that answers the question. If you have additional questions, please feel free to continue to ask because I'm happy to kind of flesh that out to make sure that I'm answering your question. I'm answering the question that you need answered. Okay, so another question. A former board member is using our nonprofit's name to solicit funds for their own benefit. What can we do? Ooh, whoa, okay. This is a good question. So one, there's a lot of things going on. There are a lot of red flags that are going off in my head with that question. So the first question that I want to start off with is the nonprofit's name and the use of the nonprofit's name. So your nonprofit name is a trademark. And even if it's not registered, you can still generally claim rights under your name as a trade name under common law for your state. If you could let me know what state you're in, please let me know what state you're in and I can tailor it to be more specific. But generally under your state's law, you will have common law, what's called common law trademark rights, or your trade name, which is the nonprofit's name. And as a nonprofit, generally you're going to have this goodwill, this reputation, this trust with the community, obviously, which then in turn makes the community want to support the work and the efforts that your nonprofit is doing. And generally that support comes in charitable donations and contributions. So there's one aspect of that, right? That you have claims through common law trademark, or if you have it registered as a trademark, either a state trademark or a federal trademark, then you have even stronger rights under that registered trademark for the name. So that's one thing. They're infringing on your name and using your goodwill to then solicit funds. The other thing that you can think about is that this is just fraudulent on behalf of a nonprofit. So the law says that a nonprofit is generally, in most cases, if it's a charitable nonprofit or what we call a 501c3, that nonprofit is generally owned by the public. And that's basically what the law says. And if they are deceiving the public, and the public is thinking that they're donating to your nonprofit because they're using your nonprofit's name, not only is that infringing on your rights, but that is also fraudulent. And with that, the Attorney General, your state Attorney General, you can file a report with your state Attorney General for that fraudulent behavior. The Attorney General of every state is generally the governing authority in the state for nonprofits. And so filing and reporting that nonprofit is going to be what will kick off the penalties and will help you to recover and stop that nonprofit from doing that. One of the other things, in addition to filing a complaint or reporting that with your state attorney general's office, is sending a letter from your nonprofit to the infringing nonprofit who is using your nonprofit's name. So what you'd want to do is you'd want to send basically what we like to call in the legal world a demand letter, or like a cease and desist letter. And basically that letter will state, hey, this is our name. We've been using this name for this long. We have this reputation in the community based on our work. You are using our name fraudulently without our permission. You do not have permission to use our name. Stop immediately, or stop by this date, or else we will need to escalate this to, and whatever those remedies are, maybe a lawsuit, maybe I don't know what state you're in, so I can't speak to what remedies are available to you immediately, but maybe that's a lawsuit. Maybe that is reporting them even with the IRS. So in addition to supporting them, reporting them to your state's attorney general's office, you can also report them to the IRS, because that nonprofits are also governed by the Internal Revenue Service. So those are the three immediate things that you can do in that situation. Send them a letter directly stating that they do not have authorization to use the name, and that the use of the name is not only infringing on your either registered or common law trademark or trade name, but it is also fraudulent and deceptive in the community and then in the public, and then report them to the Attorney General's office for your state and the Internal Revenue Service. So I hope that helps. Is it in my best interest to create a holding company and streamline everything together? So I am not certain if it is in your best interest, just because I don't have the details of what you're planning to do, what your financial situation is, and what the overall arching goal is for your business ventures. However, what I will say is that there are pros and cons to creating a holding company. And I have two very specific YouTube videos that go into detail a little bit more about this. But some of the pros for creating a holding company is that it does create an additional shield of liability. So as I was saying earlier, when you create an entity, either an LLC or a corporation, that becomes a separate legal person from the individual. So again, I have me, Maresa, and then I have Talbert Law Office. We are two separate people under the law. And so what a holding company would do is create a third layer of the holding company, the corporation, and then me as the individual person. And so there is a such thing called piercing the corporate veil. And what that means is that by some function or some misconduct, something I did wrong, or some function of just like not having my ducks in a row, maybe I didn't pay my taxes on time, and then my business went suspended for 2 weeks or something. And in that 2 weeks, somebody came and said, you gave me bad legal advice, right? Then they can come after me personally, because they can now pierce the corporate veil, because my corporation, I did something, I didn't pay my taxes on time, I got suspended, so my corporation no longer exist. So now the only person that's left, once they pierce through the corporation, the only person that's left is me. But when you have that third layer of a holding company, they need to go through the holding company, through the corporation, and then to get to you. So it's a little bit harder to pierce that corporate veil when you have a holding company, if you are using that holding company correctly. So that is a pro for the holding company. The other pro for a holding company is it separates your liabilities. It separates your assets. And so when someone does want to come after you, let's just say, for example, you own a restaurant. Let's take, for example, McDonald's, right? Everybody knows who McDonald's is, very well known. So let's just say we have the McDonald's Corporation, which is the holding company. And then we have the franchises of the McDonald's companies that are owned by many different people. And then you have the owner. Let's just say you're a franchisee of McDonald's. So you have you as an individual, you have the McDonald's and the McDonald's Corporation. Let's just say someone is in your McDonald's and they slip and fall and they sue McDonald's. Well, they can only get to your corporation of the McDonald's because, or let me take that back. They sue McDonald's. They want, let's just say McDonald's is known for being $100 billion company and they're suing for all $100 billion. Well, they're not going to get that because the McDonald's Corporation holding company owns all the major assets of the McDonald's. So let's just say McDonald's Corporation holds the real estate, the land, the value, the land that every McDonald's is situated on. They own the trademark for the McDonald's. They own all the intellectual property for the McDonald's, and they don't do any business. They just own all of this intangible stuff. So when you sue McDonald's, you can only sue McDonald's for what this McDonald's is worth. You can't sue McDonald's for what the corporation and the McDonald's is worth. I hope that's making sense and being clear. So that's another benefit of having a holding company. Now, there are some cons to having a holding company because if it's not set up correctly, it's just trouble. It's just a headache. But there's a lot of upfront costs for starting a holding company. That's another con there. It's kind of pricey upfront, but then you can streamline operations throughout. So it somewhat evens out if you are, once it's set up properly, it evens out with the financial risk because you are paying for one thing amongst multiple companies as a holding company generally. And so like I said, there are some pros, there are some cons, but I don't know if it's in your best interest just because I don't have all the facts and the details. But like I said, go to my YouTube channel and look at type in holding company, go to Talbert Law Office on YouTube, click holding company in the search, and those two videos will come up. And it will go into much more detail explaining the benefits and the pros and cons of the holding company to kind of help you get some additional clarity around it. Okay, our nonprofit operates in both California and Oregon, but this specific issue is happening in California. Okay, great. I'm very familiar with California nonprofit law, and what I told you stands exactly. You definitely can bring a lawsuit. I wouldn't start off with that, but the letter and the report to the Attorney General and the IRS are going to be your best bet. The California Attorney General is very has a very strict arm on nonprofits, and so reporting them and telling them and detailing how they are defrauding the public by using your name will definitely start an investigation. So that's what I would say. What's the best way to handle disputes with clients over contract terms without damaging the relationship? Oh, good question. Okay, so there's a few things. Depending on the contract terms, in the contracts that I write, I like to put a dispute resolution clause. So what I would say is look at the contract and see if there is a dispute resolution clause. And one of the things that I like to always put is if there is a dispute over this contract, let's try to negotiate between the parties for 30 days in good faith. Okay, let's just see if we can talk it out and see if we can come to a resolution. And so that's what I would suggest first. Let's go have coffee because there's a relationship here and I don't want to mess up this relationship, but there are some obligations and we do have a contract. So let's see if we can work this out. Then I like to say, If the parties cannot negotiate and come to a resolution within 30 days, then it can escalate to mediation. And you would go to a third party mediator. It can be a professional mediator that you both agreed to. It can be a general another mutual contact that you both agree to mediate, and you see if that works. And you give that a 30-day run and see if a third party can assist with helping you all come to a resolution. Because just like in therapy, sometimes people can hear the same thing from someone else and then it finally clicks. So sometimes it's just a matter of tensions are high. I can't receive from you. You can't receive from me. But if we get a third party here, then maybe we can both, agree to disagree, but we can come to some sort of resolution. So that would be my next step. If the parties can't negotiate in good faith and come to a resolution, then escalate it to a mediator that you both agreed to. Now, if that doesn't work, depending on the contract terms, and if you have a dispute resolution clause, it may state that any disputes have to go to arbitration. Now, arbitration is like a private, more fast-paced lawsuit. When you go to arbitration, generally, it's not going to be in the public eye. It's not as long. Sometimes it can be, but it's intended to not last as long as a trial in a court of law. And then you both get to decide and choose on who's going to be your arbitrator. And then that's going to be a binding decision that you both can kind of walk away from. Now, arbitration is, you can't just choose arbitration. Arbitration has to be a function of a term in the contract. So it has to be written in the contract that you're going to resolve a dispute through arbitration in order to do so. Mediation is not the same. You can go to mediation even if the contract doesn't require it, but arbitration has to be based on the contract terms. So if you have a dispute resolution clause that dictates arbitration is the resolution, then you would go to arbitration, hopefully after you've gone through steps 1 and 2. Now, if there's no arbitration clause and that's off the table, and you've gone through, trying to negotiate directly and trying to get a mediator, then the last resort is if you want to take it as far as to file a lawsuit, which I try to avoid at all costs. In most cases, people do not. They want to avoid lawsuits. And hopefully, if there's a prior relationship, then all the parties can rely on at least that much and then come to the table with something and try to work that out. So I hope that kind of answers the question. You don't want it to get ugly in a lawsuit if you can avoid it, but sometimes it's necessary. Sometimes it's worth it. And sometimes it just has to be done. What other questions are there? Let me see. Okay. Well, while we are allowing more questions to come in, I will generally continue to talk about some of the changes that are happening in the business world and in the intellectual property world. So I talked about the changes that will be taking place at the U.S. Patent and Trademark Office with the increase in trademark fees. But there are also some changes in the law specifically that have happened. I see some, people in here from California. If you work with independent contractors, there was just a law that was just passed either last month or this month, called the Freelance Isn't Free Act. And that's kind of the colloquial name for it. But what it is requiring is that if you work with an independent contractor, that you have to have an independent contractor agreement, which a lot of people don't have. They just say, hey, let's exchange information. You're going to do this. I'm going to pay you this. We'll get it done. But now there is a legal requirement for all independent contractors to engage in an agreement with the person that is hiring them. The law also requires that that contractor must be paid within 30 days after they've completed the work. The other kind of practical thing, that which is not a part of the actual law that was passed, but it is law that has been in place, is if you are hiring specifically an independent contractor, and you pay them over $600, they need to be reported in California with the California EDD, which governs all employees. They also need to be reported with the IRS with a 1099 at the end of the tax year. So if you work with independent contractors, make sure that if you're specifically in California, or you work with independent contractors that live or work in California, that you are aware of that Freelance Isn't Free Act. I have a video on YouTube kind of outlining all the requirements for that. And we also have an independent contractor agreement that you can purchase from the TLO Marketplace. If you go to talbertlawoffice.com, click on the TLO Marketplace, and you can purchase an independent contractor agreement with a user guide that shows you exactly how to use it. The other thing with independent contractors is making sure that they are properly classified. So this is across all states, that you have to make sure that an independent contractor is not misclassified as an employee. Otherwise, there are many penalties for doing so. One of the ways to make sure that you're properly classifying an independent contractor is thinking about the control factor. Do you control their working hours? Do you control how they complete the work? Do you provide them with the equipment and the supplies for them to complete the work? Is it something that you had to train them on? So if you're saying, for example, if you hired me as an attorney to conduct and provide you with legal services, right? Am I your employee or am I your independent contractor? Well, one of the things is, did you have to train me on how to do my job? No. Did you have to give me the supplies and the computer and the desk and, everything that I need to do my job, to provide those legal services? No. Do you control my working hours, or do you give me, hey, I need this done, and I get it done and give it back to you, right? You don't control my working hours. Do you control the mode and the manner in which I get the work done? No. So I would be classified as an independent contractor, whereas an employee, you generally have working hours, right? You have to be in the office from 9 to 5, or you have this shift from 6 to 12, or something of that effect. If you have to train a person, such as, if I have to train you on how to cook the fries at McDonald's, and I have to provide you with the uniform, with the shirt, with a name badge, or, different things to do your job, then I'm leaning more into that is an employee. So those are kinds of things that you want to consider when you're thinking about hiring an independent contractor and classifying an independent contractor versus an employee. Very, very important, because if an independent contractor is misclassified, then they become an employee, and then you are responsible for all the back pay, for all the work breaks, missed meal period breaks that they are supposed to get, payroll taxes, workers' comp, all of that stuff then kicks in, all their benefits and all of that kicks in, and then that's just a headache. So be very wary of that. So that's another one of the laws that have just recently passed, and it looks like a couple of states might be in gear to follow that. How do we go about setting up a consultation? Well, we can put the link in the chat. Let me put the link in the chat for a consultation right now. One of the ways, you can go to talbertlawoffice.com and just fill out the contact page, but I will give you the link directly to my calendar. So I'll put that in the chat right now. One of the other changes that has occurred that businesses might want to know about is the FTC ban on non-compete clauses. So there was a Federal Trade Commission ruling in September, or before September, so I put the link in the chat. I'm sorry, I'm skipping back and forth. I just put the link in the chat for anybody who wants direct access to the calendar to book a consultation. But going back to changes in the business world. So as entrepreneurs and creators and even people who are working for other folks, the Federal Trade Commission had ruled earlier in the year around April that in September, it was going to be implemented where there was going to be a complete federal ban on non-compete agreements, which means that businesses would not be able to tell an employee, you can't go work for some other company that is similar to ours. So it's like an employee at Coca-Cola being told that they can't go work at Pepsi, right? So depending on your state, some states are very lenient on non-compete agreements, and some states already are pretty strict on non-compete agreements. California is one of those states that are very strict on non-compete agreements. They don't really allow them anyway, but that is not across the country. So the Federal Trade Commission said, nationwide, we are banning non-compete agreements. You cannot tell an employee that they cannot go work for another company that is similar situated or one of your competitors. Well, that was supposed to go into effect September 2024. About a week before that happened, there was a ruling, a district court, federal court ruling that said that the Federal Trade Commission overstepped their boundaries, and they completely rescinded the FTC's ban on non-compete agreements. So what does that mean? That means that businesses can now put non-compete clauses in their contracts. So they can prohibit you from going to work for another company, depending on your state. So you'd have to see, does your state allow this? Does your state not allow this? So it's still in the works, and it's up in an uproar right now. But as of now, the non-compete ban is gone. It's not here to stay. So non-compete clauses and prohibitions on working for a competitor are still allowed, generally speaking. So that's one of the other changes that has gone into effect this year. There was one more that just came to mind and I lost it. Sorry. It might come back to me. I don't know. It left me that quick. Are there any additional questions while I'm trying to think about other changes in the law? Oh man, what was it? No more questions? Thank you, the Living Planner. BOI for LLCs, great point. That is a great reminder. So the beneficial ownership information report. I don't know how many of you have heard of it, but that went into effect this year as well. Thank you, Kampala, for that great reminder. And what that is the Financial Crime Enforcement Network, FinCEN, which is a function of the Department of Treasury. They implemented this BOI, which again is the Beneficial Ownership Information Report. And that is for all businesses, for LLCs, for partnerships, for corporations. It is for all entities except for basically nonprofits and except for like banks. There's a list of 24 exclusions and exceptions to who has to file this report. But basically, it was imposed on all entities that are making less than $5 million annually. And this BOI reporting went into effect because the FinCEN, the Financial Crime Enforcement Network, said that they're trying to crack down on money laundering. Now, I don't know how money laundering is happening most with businesses that are making less than $5 million annually, but that's out of my pay grade. So what it requires is that the owners, if you own at least 25% of any one of these types of entities, again, LLCs, corporations, partnerships, that you have to file this reporting. So initially, if your business was created before January 1st, 2024, then you have until January 1st, 2025 to file your report. If your business was created at any time in 2024, then you have 30 days to file the report. And the penalty for not filing in a timely manner, it could be up to $500 a day. I think it was a 1-year imprisonment option as well. And it's just a report basically kind of giving your personal information, your home information. You had to give some sort of like driver's license or passport number to kind of identify you. It's a short report, but it's very intrusive. And it's basically putting you on this financial crimes network system as if you're guilty of some financial crime. But it is required. So there was some argument over that where it was struck down. There was a lawsuit that occurred about halfway through the year. It was struck down by a federal court, but it was only struck down for the people who were actually in the lawsuit. So it remained active and still imposed and implemented for everyone else. There's still a lot of discussion over whether that's going to continue to be in place, but as of right now, it is, and I think it probably will continue to be for the foreseeable future. And If you have not done so, make sure that you complete that filing by before January 1st, 2025, because they are looking to impose those $500 a day fines for every day that you are late in the filing. So that is something else that came up. If you need more information, I have a tutorial video on how to file that if you need help with filing that. And let me see if I can find it while I'm kind of here. I talked about quite a few videos, the holding company videos, and that one specifically. But yeah, if you need help filing it, it takes about 5 minutes. It's not very difficult. It's just kind of annoying to have to do it. So that is one of the other things that went into effect this year. Thank you again. So many things. The last thing, as we kind of wrap up for the last 10 minutes, is just talking about contract terms. I want to kind of go back to the contract terms and the handling of the disputes. I have a workshop that is posted on YouTube about kind of what to look for in contracts and how to understand your contract terms. And I just want to kind of give a brief kind of overview discussion on how important it is to review your contracts, to have an idea of what to look for. And that doesn't mean you're going to catch everything, but at least you are getting more familiar each time with what these clauses mean, because in a contract, if it is well written, every word matters and every word has a legal meaning. And so it is just important to make sure that you're reading those contracts. If you don't understand them, get help. Please seek help, because contracts, I've been doing I work with a lot of contracts. I see a lot of contracts. I read a lot of contracts, but I also come into contact with people who their life has been just overturned on contracts. One of the most recent videos that I talked about is the Disney lawsuit. And I don't know if you all have heard about it, but there was a couple who was visiting one of the Disney parks, and they went to a restaurant. The woman, she informed the waiter that she had an allergy. They told her that they would cook her food allergy free, and they did not. She ended up passing away because of eating the food at the park. And when her husband sought to bring a lawsuit against Disney, they said the lawsuit could not be filed because he was a Disney Plus subscriber. And in the subscription, in the terms for the subscription, it states that any dispute with Disney cannot go through the court of law. It has to go through an arbitration. And I kind of talked about arbitration before, but arbitration is a much more controlled process than the court of law. And when you have a client like Disney who is choosing you to go through arbitration, many times over, there is a slant, there is a bias there, because this is one of your biggest clients and you want them to continue coming back to you for arbitration. So while it may not be overt, and while it may not even be intentional, as an arbitrator, a one-man show, there is more likely than not some inherent bias, as this is one of your biggest clients. In a court of law, you have the right to a jury trial, which is peers, people who live regular lives every day and understand, if my wife died because I ate at your restaurant, then you're responsible. And that's the kind of thing that Disney wants to avoid. And they couch that in their Disney Plus subscription terms and conditions. So because he had a Disney Plus subscription, they responded and said, oh, sorry, you can't bring this in court. You got a Disney Plus subscription and you agreed to the terms. The only thing that helped was that there was so much public outrage over this that they withdrew their statement on saying, okay, we won't go through arbitration. We'll take it to court. And that is ongoing right now. That just happened earlier this year. The case is still ongoing. And so I will leave you with that. It is very, very, very important to understand the nexus and to read these contracts to know. And even sometimes when you read them, you're still going to forget them. And who's reading terms and conditions? Have you seen Apple's terms and conditions for like anything, like Apple Music or any of their software? It is 10 miles long, okay? And it's like in like 8-point font. Who's reading that? Who is reading that? You just want to get through it and click agree and go on. So it's important to know that you're signing your life away, literally. And for the moments that you can and for the opportunities that you do have to read or to seek help to read contracts, please, please do, because they are very, very, very important. So with that, if there are no more questions, I will go ahead and wrap this up. Thank you so much for your questions, for your attention. Thank you for being here. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property. And I hope to see you at the next live. Talk to you soon. Bye-bye.